Jetty Bay CPO proposed by Fife Council. Can you once again just raise your hands to show you can all hear me? That's great, thanks very much. Just some very quick reminders. Reminder that we're being webcast and recorded. Reminder to keep videos on other than in breaks, but mute your microphones when you're not speaking. Make sure mobile phones are on silent, and we don't have a fire alarm test scheduled for today. Before we resume, are there any matters arising overnight that I need to be aware of? No,
Nothing.
good. Nothing. That's good to know. Okay, so yesterday we heard evidence for the acquiring authority from Mary Stewart, Andrew Riley and Ronnie Hare. So Mr. Devlin, I can invite you now to introduce your next witness.
Thank you, ma'am. The next and final witness, in fact, for the council is Chris McMenemy. He is in property and planning. He is in property and planning and is as the research and information coordinator in business and employability services of Fife Council. I don't have any questions in chief for Ms. McMenemy, so Mr. Collar can just proceed with his cross-examination.
Thank you, Mr. Collar.
Thank you very much. Good morning, Mr. McMenemy. Just again, to help everyone with paperwork, I think the only two things I'm going to refer you to are your precognition and then the Fife Employment Land Strategy, which is FC11. It'll save us scrambling around when the time comes. Okay, thanks. Starting with your recognition, and in paragraph 3.3, you refer to the Fife Employment Land Audit 2021. We've heard that the CPO was made in August 2022. The Employment Land Audit of 2021, am I correct that that was published on 7th June 2022?
Yes.
Yeah. But was presumably known to council officers prior to that. I'm assuming it went through some sort of committee approval process to get published.
Yeah, the report was reviewed by colleagues in economic development, signed off by head of service.
Yeah. So the fact that the statement of reasons for the CPO made no mention whatsoever of the employment land audit, that's quite strange, isn't it? Because not only was it published before the CPO, but it would have been known about at least for a month or two before publication.
I'm not sure if I have anything to sort of say on that particularly.
Well, I think we can all have our own views on that. I don't think there's any point me pushing you on it. On the employment land audit, and this is picking up the issue that the reporters raised yesterday. So I think in part this is just clarifying what has already been established. The CPO site is not an employment site for the purposes of the employment land audit, is it?
No, the CPO site is not included as one of the sites within the employment land audit.
And if I've understood the methodology correctly, what is included is allocated sites and sites that have planning permission.
Sorry, broke up a little bit there. I think that the audit includes allocated sites and sites with appropriate planning permission for class 456. Yeah.
We've heard that the CPO site is safeguarded for employment use, and I'm just intrigued at the reason why safeguarded sites aren't included. So maybe the best place to start is, do you know why safeguarded sites aren't included, or is there just an established methodology and you use the established methodology?
So my understanding of the safeguarded allocations within the local development plan are that these are areas that are to be safeguarded for particular use. I think the areas cover land which is already being used for that use, and therefore is safeguarded. Should it be safeguarded from things like change of use, or if it was to be removed from the supply to be brought back into the same use that it was safeguarded for. That's my understanding, but a planner would give a better view on that, I think. In terms of the methodology for the employment land audit, it is established that there are sites allocated within the local development plan specifically for employment use as defined in the plan for class 456. And as new sites come forward for those uses through planning applications, they are also included within the supply as land that is to be brought forward for class 456.
I think I share your understanding of so I think I agree with the answer that you gave. But just to explore the point in a little bit more detail, as you say, the policy, the safeguarding aspect applies to sites that are in use, but equally apply to sites such as the CPO site, which is vacant. So the fact that the methodology does not include vacant sites such as the CPO, would you accept that means that the audit is actually incomplete as a result?
No, I think that the audit is designed to monitor the local development plan and the defined employment land strategy. Within the plan, the sites that are included that have been allocated for employment are monitored in terms of their status, and it's established that anything new that comes through the planning system for those uses will also be included in the employment land audit. We don't monitor the overall stock of employment land in terms of what is in use and has been removed, and then add that back into the audit, and that's done through applications that come through the planning system.
But that's really my point. By not doing that monitoring, the audit doesn't actually provide a complete picture, does it? Because as we can see in this case, this is a site which is safeguarded for employment use. It is therefore arguably available, and I'll come on to that in a minute, but because of the methodology sorry, I don't want to personalise it, because of the methodology the council use, this site and potentially others, because we just don't know, are not included because the monitoring approach that is used does not capture that information.
In terms of the use of the land within the safeguarded site, I suppose my understanding is that if the site is currently in use for employment class 456 and it were to be demolished, thereby reducing the stock, that would translate as an increase in requirement. The assumption being that if the land has previously had a use for employment and is within a safeguarded area, that it would then come back forward for that same use to basically initially increase the requirement and then remove the requirement, because by demolishing the building for that use, the requirement would go up. And the assumption being that the land would come back forward for class 456 and then reduce it back down. I suppose that there doesn't seem to be a need to do that monitoring within the audit and to monitor sites allocated and anything new that comes through the system.
Well, that's widening the discussion into issues which I'm going to come on to, but if we can keep on the narrow point, as a matter of fact, the audit does not include the CPO site, and as a result, that means the audit is incomplete, isn't it?
Yes, I'll agree with the point. Essentially, the land is not currently in use for class 456. Should the land come through the planning, should an application for the land come through for class 456, it would then be included within the audit. I suppose I assume what you're implying is that the land could go into the audit now based on the fact that it's in the safeguarded area and is vacant, and the assumption will be that it will come forward for class 456. We won't put it into the audit until the application for such a use comes through the planning system.
Thank you. That's a useful clarification. But in a sense, it reinforces my point that by only including the site once planning permission has been granted, that shows its incompleteness. And just to come at it from a different angle to illustrate the point, you've indicated that the audit does take account of allocated sites. Would you accept that just because a site is allocated doesn't necessarily mean it is going to come forward for development or use within short, medium, long term, whatever it happens to be?
I suppose in terms of the employment land audit, we don't project when we expect the land to come forward. The plan sets out the aspirations for land to be used, and it allocates land for particular uses. And the employment land audit monitors the development as it happens. I imagine there are sites that have been allocated for longer than others. You are correct that just because something is allocated doesn't mean that it will definitely come forward. But I suppose the aspiration is that it's protected for that use, and it should as part of the council's overall plan.
And we can see from your precognition you set it out at 3.6. The audit includes land even if it falls within the major constrained category, so that's that it's got a constraint that is unlikely to be overcome in less than 5 years.
Yes.
So anything that is major constrained is unlikely to come forward, certainly in the short term, but is still included within the audit.
Yes, that's right.
And as things stand at the moment under the methodology, the CPO site will not be included within the audit until planning permission is granted.
Yes.
And it doesn't matter whether it's the landowner that applies for it.
Just in terms of clarifying that, the other method that the CPO lands could come into the audit is if it was allocated within the next local plan.
Thank you. Yes. Yes. Fair point. But if the planning permission is granted for the purposes of the audit, it doesn't matter if it's granted to the landowner as a result of an application by the landowner, or if it's granted to the council because the CPO has been successful. All that matters for the purposes of the audit is that the permission has been granted.
Yes, for an employment use, class 4, 5, 6.
Yes. Then in your precognition at paragraph 3.8, you explain there, well, you're referring to the employment land strategy. We see that in the previous paragraph, paragraph 3.7. And at 3.8, you say each key settlement is allocated a 7-year general supply requirement and an additional strategic requirement in settlements assessed as having strategic importance. Fells determines that Dalgety Bay has a general supply requirement of 2 hectares of employment land, and there is no strategic requirement assigned. So we can see from that that Dalgety Bay, for the purposes of the employment land strategy, doesn't have strategic importance.
And no, that's correct.
Yeah.
The Dalgety Bay, I think within the Fife employment land strategy was, I'll actually find it. Paragraph 6.6 of the Fife employment land strategy. It states that both Dalgety Bay and Burnt Island, although considered to be strategic employment settlements, where major employers operate and where the market is focused employment development, the primary aim is to protect the existing land supply and support redevelopment of land for employment use where opportunities arise. It was identified as being of strategic importance, but the decision was taken not to allocate a strategic requirement and only a general requirement, as far as I'm aware.
Yes, and just staying with Fells and picking up the questions the reporters raised yesterday. You mentioned within your precognition, but you're taking it from Fells, so I will just try and put my finger on where it is. Yes, if we go to table 6.3 in Fells, so it's a few pages further on. It's actually on page 23.
Yep.
And we can see there Dalgety Bay, total supply 1.9, that must be hectares, I think. Total 7-year employment land requirement 2, marketable supply 1.9, and then there's the overall RAG status of amber. And I will come back to comments you made about various aspects of that in a moment. I'm assuming you weren't involved in setting the 2 hectare 7-year employment land requirement that we can see in Fells.
No, I wasn't involved in the creation of Fells.
No. So you're in the same position as the rest of us, that identifying where that figure comes from, what information was taken into account, you don't know anything more than what is actually mentioned in the Fells document itself.
No, what's in the Fells report? I would need to have another reread. I presume that the employment land audit was, in terms of the data, was part of the information that went into Fells, and that the marketable supply that's listed there is based on the sites within the employment land audit at the time. That's my assumption.
And we can see in table 6.3 that each of the settlements has a different 7-year requirement. And as the reporters picked up yesterday, Fells is, certainly according to the front cover, dated August 2014, and it's expressed to be a strategy 2014 to 2021. So the 7-year requirement, as far as we can see from that document, runs for the 7-year period that ended in 2021.
No, that's not. Well, that's not my understanding in terms of the requirement figures within Fells.
Okay. So what is your understanding, and where in Fells do you acquire that understanding?
My understanding is that the 7-year requirement is essentially a rolling requirement figure, projected 7 years forward. The requirement figure is assessed year on year to determine whether enough land is available within each key settlement against those requirements. My understanding is that, I think you're implying is that the requirement would depreciate over the 7 years, I suppose is what you're implying. But my understanding is that each year going forward, we still assess whether 2 hectares of land exists within Dalgety Bay as a rolling 7-year requirement.
And where in Fells do we see that set out?
I'm not sure that it says that explicitly within Fells. I would need to review the document, but I'm not aware that it says explicitly, but that's my understanding of the 7-year requirement is to be applied.
Because you'll appreciate from the discussion yesterday, it's actually a really fundamental point that if it's intended to be, as you say, a rolling requirement, that there is always well, I was going to say that there's always a 2 hectare requirement, but that can't actually be right as a matter of logic. A requirement is one thing. It's the seesaw analogy that you're looking to balance requirement and supply. The requirement, surely as a matter of logic, cannot remain static for year on year on year on year, because the requirement side is going to vary, surely.
Yes, I accept that the requirement figure would change year on year. I believe and understand that there will continue to be a requirement. So I suppose the alternative view here is that the requirement figure that's set from 2014 to 2021 is a requirement that depreciates over that time to 0, and that there would be no requirement as at 2022. I believe that logic would dictate that that's wrong, that there is continually a requirement for employment land in these key settlements, and that the 2 hectare figure that was established as part of Fells would continue to roll on in the absence of anything else.
Well, I would agree as a matter of logic, there must be a requirement, but that's really the inherent part of the objector's case, that in pursuing this CPO, it's incumbent on the council to identify the requirement that they're trying to address, and what the objector has to respond to is the council's case that it's put forward, and that's what the reporters equally need to take account of in making their recommendations, and I think that's where we're all struggling to some extent. But to get to the nub of this, in your precognition at paragraph 316, you say the total supply of marketable land in Dalgety Bay on 1st April 2022 is 1.7 hectares, which translates to 85% of the requirement set in Fells and a RAG status of amber for the settlement of Dalgety Bay. Now, I'm not going to get into the arithmetic of it, but what I do want to discuss with you is the weight that you're looking for the reporters to put on that conclusion, because the proposition I want to put to you is that statement is largely irrelevant because the 2 hectare requirement is out of date. So would you accept that because we don't know what the requirement is, the reporters shouldn't give any particular weight at all to what you say in your paragraph 316?
No, I think from my perspective, the 7-year requirement that's set out in FELS is still valid. MPF4 doesn't allocate a requirement for employment lands. We don't have any other strategy document that provides us with a requirement to supersede FELS, and in the absence of anything else, the FELS the strategy requirement is the requirement figure that we have to monitor against. So I feel that the 2 hectares within the FELS document is still valid and still needs to be monitored as part of the employment land audit. I accept that a note will need to be assigned to highlight that the FELS is out of date if it runs to 2021. But I believe that the 2 hectare requirement is still valid as a rolling 7-year requirement.
Well, did we not accept, though, it can't be a rolling requirement because that was the requirement in 2014, and we just don't know what the requirement is now because we don't have a document that gives us the up-to-date situation?
The alternative would be to have no requirement, and I think that would be incorrect, and that the 2 hectare requirement carried forward from FELS provides us with the requirement to monitor.
But that's really my point, that the flaw here is the council have not updated FELS on a rolling basis. So we have no monitoring information to know what progress has been made meeting that requirement. We heard mention yesterday that a new FELS is being prepared, but really, as things stand based on the evidence before this inquiry, we just do not know what progress has been made in meeting that requirement, do we?
I agree that no further employment land strategy has been prepared at this point to provide us with an updated view on what the requirement should be, whether that has gone up or down in Dalgety Bay. I believe that without that, the requirement figure from the current FELS strategy that informed the current local plan should carry forward until such time as the new FELS document is prepared and provides us with an updated requirement figure.
To go back then to what you say in 316, based on the discussion we've just had, the most accurate way to describe that conclusion, you say it's 85% of the requirement set in FELS. What the reporters should read into that is of the requirement set in FELS in 2014.
Yeah, that would be accurate. FELS was prepared until 2014, and that was when the requirement was set.
And I think you've accepted there is no information before the inquiry to carry out the equivalent calculation for the current situation because we just don't know what the requirement is at the moment?
Yes, the assessment done in the FELS 2014 document has not been repeated to give us an updated view on the requirement.
And then just finally, on the employment land audit, in your recognition at 314, you're saying we've prepared the 5 employment land 2022 site assessment. It informs the draft report is undergoing internal approval process. And I just wanted to understand what you were meaning there. The assessment informs the report. Has the report actually been drafted yet, or is it still? Is that still an action to come?
The report itself is still being drafted. The audit process in terms of taking the previous year's audit data set and assessing the changes that have happened as at 1st of April the following year. That was what was undertaken. We reviewed all the sites from Employment Land Audit 2021. We assessed any new plan applications that came through during the audit period for any windfall sites or applications on existing sites to determine the status and updates to each site. The methodology is essentially the same from the previous year. We've drawn a lot of information from building standards and planning. We consult with colleagues in planning and economic development. And that process had been carried out in advance of drafting the report, which essentially is a factual statement about the data for the audit period.
And presumably there's an internal timetable that you're all working to towards a report to committee and a publication date. So can you give us an indication of when publication is anticipated? I understand that's not going to be a commitment, but I think it would be useful even just if we had an estimate of what officers are working to.
Yeah, my hope is that the report will be available by the end of May.
And when you say available, do you mean
signed off by head of service and published for the public to view?
Thank you. That was exactly what I was wondering. So that's useful. That was all the questions I had. Thank you.
Thank you very much. I've been scribbling away because that conversation, it did cover quite a lot of the things I was interested in hearing about. I've got a few more questions though, so I will just try and make sure I don't repeat Mr. Collars. I'll start with some of the things I picked up in your recognition. Firstly, I noted that at paragraph 3.2 in your recognition, you made the point that part of the landowner's objection relies on the information contained in the Employment Land Audit 2021. And I just wanted to check, I mean, at the time the CPO was made and advertised, would there have been any information available to the objector to show them that the council's outlook or view on employment land had changed since that audit was published, or would that have been the only place they could look to see what the supply was thought to be?
The at the time, the Employment Land Audit 2021 report was the latest publication that we had of the employment land supply.
Yeah, so that you were just noting that point. That wasn't a criticism at all. Okay.
No, that was just context.
Okay. In your preparation, between the information across paragraphs 310 through to 316, explain how the reg rating system in the audit works. And I can see that what you're saying there is you're expecting the rag rating for Dalgety Bay to change from green to amber, going from the 2021 audit to the 2022 audit. You can see from the descriptions of those colours in 3.11, amber means limited availability, which needs to be augmented. It doesn't seem to mean that the land supply there is inadequate, because that's the description of a red site. So it's limited, but not necessarily inadequate. Is that a fair reading? It needs to be augmented.
It needs to be augmented is the line. So yeah, in terms of looking to bring land into the supply, the rag rating suggests that we have dropped below what the requirement is, and that we should be looking to find other sites or bring other sites forward to augment the supply.
Yeah, but for the purposes of the audit, at least, it's when a town is assigned a red rag rating, that's when you've definitely taken the view it's an inadequate supply.
Yes, that's what this one.
Okay. And when a town such as Dalgety Bay moves from having a green rag rating to having an amber rag rating, meaning now that the supply needs to be augmented, how's that normally done? Would that always trigger an action by the council?
I'm not entirely sure how the information is used by colleagues in planning or development. I suppose that would be more of a question for them.
Okay, so it's not something that when that happens between audits, a recommendation or advice goes to colleagues to say something needs to be done here. They would just have the audit showing them that change in status.
Yeah, the audit would be provided by us. We don't provide any other recommendations. Yeah, that's correct.
Okay, and I've got a couple of questions about the employment land strategy as well, FELS. So paragraph 1.6 indicates a need for 33 hectares of land, yeah, again across 20 key settlements, one of which is Dalgety Bay, and FELS gives Dalgety Bay 2 of those 33 hectares. Paragraph 3.2, this has partly been covered by Mr. Collar, but I don't think it's quite got to where my question was going. Paragraph 3.2 suggests that it was the Fife structure plan that introduced the requirement for there to be a 7-year employment land supply across the 20 settlements. And obviously the Fife structure plan is not part of the development plan anymore. So that sort of founding basis of why there was a 7-year land supply created and maintained isn't there anymore. Does the employment land audit and the requirement for 7 years supply, has that got any basis anywhere now? Is there anywhere in the development plan or elsewhere now that says there has to be a 7-year employment land supply?
Yes, I think that the local development plan states within policy 5 that I can't remember the exact wording actually.
It says that when the council considering change of use applications, that wouldn't be supported if it would create a shortfall in the 7-year land supply. So I read that as acknowledging there is one somewhere.
Yes.
But it doesn't. I wasn't reading that as to say there has to be one or what it needs to be. Just So I've got that reference. I've seen that it is acknowledged in there, but in terms of what the supply is that set out anywhere?
So Fells is where that is set out. I think you highlighted 3.2 that this originally came through from the Fife structure plan in terms of establishing the need for a 7-year supply. However, the need for 7-year supply is written into Fells. It has roots in the structure plan, presumably from this statement there, but it is written into the Fells document, which then informs the local development plan. I think the local development plan does refer to Fells within it as well.
Fells, sorry, I'm just interrupting you.
Carry on.
So Fells and Fife plan, particularly policy 5 there, they sort of depend on each other. They function between them.
That's my understanding, yes, that Fells, the LDP were Fells was written to inform the local development plan in terms of allocation and the requirements set in Fells, and the monitoring of that from the audit covers the land allocated in the LDP and the requirements set by Fells.
Okay. And there is we heard yesterday, there is a new Fells being prepared, and that will look at the next period. In terms of the timing of the CPO, I'm just interested to know why, if the council felt or knew that the next employment land audit is going to show that Dalgety Bay is an amber town rather than a green town, meaning it hasn't got the full 100% supply of the employment land you want for it. Why wasn't the CPO work coordinated with that?
I'm not sure I'm placed to answer that in terms of what people knew at the time or the reasons for either referencing or not. I'm not sure.
You asked to provide any advice on what the audit at the time was showing or what the research for the next audit was showing?
No, not.
I think that is all my questions. I'll just double check the sheet. I do have one. I do have one further question. So you confirmed to Mr. Collar that the CPO land isn't included in the audit at the moment because it's not an allocated site and it's not a site with planning permission at the moment. So in a way, the CPO scheme wouldn't really affect how the land supply is reflected in the audit until it got down the line to a point of any planning permission being in place for the development work that would follow on from the CPO scheme. But I was just looking at the figures for the land supply at the moment. So the land supply in the 2021 audit is 101%. Sorry, I haven't written down where I've seen that, but that's in one of the submissions. And it's moving to amber. The council says it's moving to amber because there will be a slight or a shortfall in the 2021 audit. I worked that out from the figures in your paragraph 3.7 as being 85%. It's an 85% shortfall then, because you're moving from 2.01 hectares, which is 101%, to 1.7 hectares across those two sites, which I've calculated as 85%. Feel free to check that if you want to. So in a way, this is immaterial because the audit, the CPO scheme won't bring the site into the supply. But I've also calculated that if you did bring the audit land into the supply further down the line, and other things hadn't changed from how you reflect them at 3.15, you'd have just over 3 hectares. So you'd have about or over 150% of the land supply there. So if I mean, it doesn't appear that it is from the line of conversation, but if an argument for the CPO was that you need to bring that in the land supply to bring the land supply as reflected in the audit back up to what it wants it to be, it would go beyond that. Does that sound correct?
Yeah, I think in terms of your calculation, once the CPO land had an application for class 456 or was allocated in the plan, if nothing else changed, it would go above the 2 hectares. Yeah, I think, yeah.
Yeah, I just wanted to check that understanding was right. Okay. I don't have any further questions for you. Thank you very much. Mr. Warren, do you have any questions?
Everything I pre-prepared and jotted down during questioning has been answered. Just something that sprung to mind just as we were finishing up there, though. In terms of, so yesterday we asked about the kind of the relevant geography and this concept of the Southwest 5 wedge. I don't want to kind of go over that again, but is there anything before us where or anything which you use which could give us a sense of how much land might fall into the kind of same category as the CPO land, where it's not captured by the audit, but it's there and potentially vacant and does in practice add to the supply in that area? Is that captured anywhere?
In terms of, I suppose the point that Mr. Collar made earlier on in terms of land safeguarded and vacant but not within the audit, is there anything else that we monitor?
Yeah.
No. In terms of the what we look for the audit, we're looking for the allocate sites within LTP. We're looking at the applications that come through for class 456 and through the planning system. In terms of the Southwest 5 discussion, Fells obviously sets out the key settlements in terms of the requirement for each of those.
Yeah.
We have the RAG statements against all that. I think in terms of the Southwest 5, the other I'm not quite clear on the geography that everybody was meaning in terms of Southwest 5. I suppose my understanding of Southwest 5 would be the area committee boundary. Familiar.
That's perhaps less important, yeah. So probably made it more complex than I needed to. So it's more a question. I mean, even thinking about just Dalgety Bay, is there anything that can kind of indicate how many sites or whether there are other sites that fall into this category that kind of that don't get picked up by the audit?
Yeah, I suppose if considering the Southwest 5 this discussion, the other settlements within that area, which would be Inverkeithing, Rosyth, and the Southwest villages, are all showing a RAG status of red within the Employment Land Audit 2021 report, and have quite a low supply in terms of the requirement that's set out in Fells for immediately for marketable land. Obviously, we're focusing here on Dalgety Bay, and within the Employment Land Audit 2021, that states that it is green. But I suppose if you're looking at the wider Southwest 5 area, I suppose the audit and the data we prepare would indicate there's a shortfall in the other areas of Southwest 5.
Okay, thank you. I don't have any further questions. Anything?
No further questions for me. Mr. Devlin, do you want to ask further questions?
No, I don't have any questions. Thank you, ma'am.
Okay. So we have heard now from all the witnesses for the final council. I propose we take a break now. Can we reconvene at 10:45, and then we will hear from Mr. Stewart. Okay, back at 10:45. Thank you.
Thank you.
Welcome back. Okay, thanks for being back on time. So, Mr. Collar, it's now your turn to introduce your witness.
Thank you very much, Madam. The witness for the objector is Mr. Graham Stewart. He's submitted his precognition. We're taking those as read. I just have a few supplementary questions for Mr. Stewart, just picking up on matters that have been discussed at the inquiry. So, Mr. Stewart, on the issue of retail use of the site, following the council's response to the pre-application consultation, which was a fairly firm thumbs down, is there any intention on behalf of the landowner to pursue the retail use any further, or is it a dead duck?
That's a dead duck as far as we're concerned. The council's opinion on that was made very clear, so it's not something that we're looking to pursue at all.
And then just to give you, I suppose, a chance to respond to the council precognitions and whatnot. Since writing your precognition, you've had a chance to see the council witnesses' precognitions. You've heard their evidence at this inquiry. Is there anything that you've seen in the precognitions or anything that you've heard today or yesterday that changes the comments and conclusions that are in your precognition?
No, nothing at all.
Thank you. And then just one point from your precognition, conscious that we're taking everything else as read, but just wanted to pick up on one thing. At your paragraph 2.1, you say that the land's been owned by the company since July 2018, when it was purchased as part of a wider portfolio, and we heard about that yesterday, including the land in question, as well as two large buildings totaling 78,500 square foot on the estate. So we can see there that as well as the CPO site, the objector owns two other large buildings on the estate.
Yes, that is correct.
So Mr. Hare's evidence yesterday, he was putting some weight on feedback that had been obtained from other landowners and users within the estate, and possible detraction from users' perspectives based on the condition of the CPO site. So the concerns he was mentioning, the impact of the CPO site is something that would impact on the objector company, as well as others in the estate, because the objector company also owns those two other large buildings.
Yes, that is correct.
And given that the landowner owns the CPO site, presumably you would have done something about the CPO site if it was having that detractive, if that's correct English, effect, as Mr. Hare was claiming.
Yeah, that's correct. I mean, we've never had any feedback from, it's one large tenant we have there in Genico. They've got two buildings. We've never heard anything from the tenant on that, or from the tenant's agent.
Thank you very much, Mr. Stewart. That was the supplementary questions I had, Madam.
Okay, thank you very much. So over to Mr. Devlin for cross-examination.
Thank you, ma'am. Good morning, Mr. Stewart. For ease, as Mr. Collar has done with the council's witnesses, the documents that I'll principally be referring to are your precognition, document FC5, which is the council's response to the landowner's original objection, document FC8, which is the circular, your statement of case, and also the council's statement of reasons.
Yeah, that's fine.
Mr. Devlin, I'll get those documents together if you want to push on with the questions meantime.
Thank you, Mr. Collar. I was just waiting for Ms. Swift-Adams, the reporter, just to make sure she was in place.
I've got those all out now, thank you.
Thank you very much. I'm starting with paragraph 3.5 of your precognition, Mr. Stewart, where you say the threat of a CPO seems to be an unnecessary knee-jerk reaction to a pre-application regarding Class 1 retail consent for this site. If I could take you, please, to paragraphs 7 and 8 of the circular, that's document FC8. Paragraph 7 begins, where practicable, the authority...
Sorry, Mr. Devlin, can you just give me a minute? I'm being a bit slow.
Sorry.
That's all right. Just to check, is that the circular 6 of 2011?
Yeah, that's the compulsory purchase order circular, yeah. Paragraph 7 begins, where practicable, the authority should try to buy the land it needs by agreement before making a compulsory purchase order. And then paragraph 8 states, there is little to be gained in prolonging unproductive negotiations if the authority is prepared to make a compulsory purchase order. In some cases, there may be benefits in making a compulsory purchase order in parallel with negotiations to purchase by agreement. Can I then take you, please, to document FC5, which is the council's response to the landowner's initial objection. You'll see at page 1, there is a table of communication between the council and the landowner, in particular the various agents that this landowner has had. I'm not proposing to read through every line in the extensive table, but just to pick out a few, for example, on the 25th of May 2018, there's an email to Ewan Burns looking to engage regarding the purchase of the CPO land, in which a potential of CPO is mentioned. Joint venture arrangements are mentioned in October 2019. On the 9th of August, the council contacts Mileway to state again their interest in purchasing the CPO land and to notify that the council will be seeking committee approval to progress with the CPO of the CPO land. And on the 19th of August, the council contacts Mileway, which I believe was yourself at this point, based on the 13th of August email above, to open up discussions regarding the purchase of the CPO land and to provide an update on the committee approval that the council had received to progress it. So what we can see here is a very significant engagement with the landowner, albeit through the landowner's agents, in respect of the potential purchase of the site and also CPO of the site. So the CPO itself is not at all an unnecessary knee-jerk reaction to a pre-application regarding Class 1 retail consent for the site, is it?
I think they're referring more to the timing of that one, which I think we touched on yesterday. The CPO threat was there, and the CPO had been signed off, as we discussed yesterday, back in 2021. The CPO wasn't served until a day after the asset manager had sought a meeting for pre-application approval for retail consent. So that's why I took that as a knee-jerk reaction to that pre-application, which I think was a fair assumption on my part.
Well, in terms of internal processes and so forth, actually to do these things, local authorities, as you might imagine, cannot simply do things one day and then do something different the next. So that we'll just note that that was an assumption on your part, but the council's position is that it was not a knee-jerk reaction. Moving on now to my next question. My next question was actually going to be about what was intended for the site. Mr. Collar helpfully asked you about that initially. You've indicated in your statement of case at paragraph 3.5 Sorry, forgive me. I think that this might actually be your precognition at 3.5. Forgive me. That the council have raised a CPO action to prevent a potential application from being submitted. Although it was noted in questioning, I think, of Mr. Hare yesterday, that there may be a financial implication if you did, in fact, make an application of some description. There's nothing that actually prevents an application from being made. Is that correct?
There's nothing that prevents it, but my understanding is that when the land is under a CPO order, the landowner shouldn't take action to effectively try and gain financially from that, such as seeking planning permission for higher alternative uses. And that was the advice that we were given.
Are you familiar with the principle of a certificate of appropriate alternative development, Mr. Stewart?
Nope, I'm not.
It's a legal point, and I'm sure Mr. Collar will correct me if I say anything that he disagrees with, but a certificate of appropriate alternative development is a mechanism within compulsory purchase legislation that enables a landowner to test an alternative use of any land where a CPO is occurring, in the event that, as in this case, for example, the land is sought for class 4, 5, 6 uses. That is the payment that is made if the CPO was successful. But the landowner considers that an alternative use, such as retail, although you've indicated you've now dismissed that, could have been obtained. Therefore, when you say in your precognition that you don't necessarily have an opportunity to have a planning application made and effectively to test that, you do have an opportunity within the CPO legislation to test whether or not a retail development would be possible in terms of a grant of planning permission. Are you satisfied that that would be a correct position with a certificate of appropriate alternative development?
That's the first time I've heard of that, so I would need to obviously discuss with our council, take advice. That's I'm not a planning officer, so I need to take advice on that.
That's understood. That's absolutely fine. I'd like to move now on to the circular again, which is document FC8. And in particular, paragraphs 14 and 15 of the circular. The order itself states that it is for the redevelopment and improvement of the area in the interest of the proper planning of the area. Paragraph 14 is about assessing the public interest, which is something that you've raised in your precognition as well. The circular indicates that in some cases the public benefit in a scheme may be economic. For example, it may create jobs or encourage investment. It doesn't say guarantee investment or anything, but it says encourage investment. The council proposes initially to CPO the land in order to remediate the site, remove the concrete plinth, make it ready for development, introduce an access road, things of that nature. In terms of public benefit, do you agree that making the site oven ready in that way would demonstrably have the impact of encouraging someone to take the site forward for class 4, 5, 6 uses?
Potentially, yes. I think Mr. Riley touched on it yesterday, and it all just comes down to cost and viability. If the council undertake those works, the sale price would reflect those works being undertaken. If we were to sell the site without those works being undertaken, then that would reflect that. So it may encourage someone, but it may not. It's not a guarantee.
That's fine, thank you. We'll note that you said that it certainly may encourage investment, although also that it's not necessarily guaranteed. If I could also turn to paragraph 15 of the circular. This states, in assessing the public benefit, a local authority may wish to consider, amongst other things, priorities that it has adopted in its single outcome agreement or proposals, projects, policies adopted in its development plan, other strategic or planning documents, a number of different sources that are available to it. If I could take you to the now infamous statement of reasons of the council. In particular, if I could take you please to section 7 of that, the justification that the council sets forth. The justification that is set forth refers to a number of different documents which are approved and adopted by the council. We've got the Plan for Fife document mentioned. We have Fife's Economic Strategy 2017 to 27. We have the Employment Land Strategy, which we've just discussed with Mr. McMenemy. And there should also be a mention in there of the Yellow Book report, which is lodged as well as a document. One of the threads that runs through those documents is regeneration of industrial assets or industrial estates. The council, at its statement of reasons in section 2, states the remediation of the site servicing of the subjects would also contribute towards the ongoing regeneration of Hill End and Donnybristle industrial estate. Regeneration of industrial estates is a priority for the Fife Council, and there is an ongoing concern that a lack of modern business property and effective employment land is having a detrimental impact on the Fife economy and the region's ability to attract investment. Therefore, when considering the proper planning of the area, and in particular the ongoing regeneration of not just this industrial estate but a number of others, the council has referred to a number of documents, and there is clearly a thread running through those documents of the public interest of regeneration of the industrial estate. Would you agree with that statement?
Would I agree that there's a common thread running through all of those documents? Is that the question?
There is a thread of regeneration of industrial estates running through those documents.
I don't disagree with that.
Thank you. Turning back to your precognition, at paragraph 3.3 of your precognition, you state the fact that the council have an existing site in the immediate vicinity which remains on the market and unsold demonstrates that there may be a lack of current demand in the area for developers, large or small, to build in this area. I think that the site that you're referring to in that statement is the 24 Ridgeway site, which we were discussing yesterday to a certain extent. And it was disclosed in evidence yesterday that the site is now under offer, and that there were more than 12, I think the total number was 14 or 15 interested parties. Do you wish to revise that statement that there may therefore be a lack of current demand in the area for developers, large or small, to build in this area?
I think what we've written there, which remains on the market and unsold, as of today, that property remains unsold, which is a fair point. The lack of current demand in the area, if there was 15 serious offers, then yes, possibly. But like Mr. Hare said yesterday, there was 15 offers, including a couple of serious offers. So I don't know if that's 2, I don't know if that's 3, I don't know if that's 4, I don't know what those uses are. But from what I took, there were a couple of serious offers. So there may point to there being a demand. But again, at the time of me writing this, and without actually knowing what those offers were and who those offers were from, I couldn't comment.
That's understood. Your recognition is a snapshot at that point in time. That's accepted. But we now have an updated position in respect of that particular site, and I'm just wanting your view that the site being under offer at the moment, and obviously that does mean that there's a contract to purchase being negotiated, but that does tend to demonstrate that there is in fact a demand for class 4, 5, 6 uses in this particular location. Is that correct? Would that be correct to say that?
If that deal concludes, then yes, I would concede that.
And in terms of market demand, I do take on board the point that it's for the council to present its case and it's for the council to persuade the reporters and ultimately the ministers of the position. But in terms of market demand, what counter evidence have you provided, aside from statements that have been made in your statement of case, your recognition and so forth? What counter evidence has there been presented to the inquiry that there is in fact no market demand for what the council is proposing to do?
I think it's very hard to prove a negative. And like you said there, the onus is on the council here. The onus is not on us to provide alternative evidence. The onus is on the council to provide positive evidence. That's fair enough, Mr. Stewart. I don't actually have any further questions for Mr. Stewart. That concludes my cross-examination.
Okay, thank you very much. I do have a few questions, and I'll just update them as I'm going along to reflect the update you provided on your retail proposal. Just in terms of some of the timings, you received the pre-app advice from the council on the 26th of September 2022. In answer to Mr. Collar just a few minutes ago, you confirmed you weren't now considering taking retail option forward. My reading of your statement of case, which was submitted on the 28th of March this year, gives me the impression that at that time, so March this year, you were still considering retail, and that's because at 2.4, at the end of paragraph 2.4, you refer to the fact that you would consider other options if planning permission isn't secured for retail. So I'm just interested to know when did you take that decision not to take the retail proposal any further?
I don't have the exact dates, but to give it a bit of context here, we're an industrial landlord. Our entire portfolio is made up of industrial estates. Any what we consider non-core uses, so any retail, any offices that we've acquired as part of larger portfolios, have generally been sold off. The reason that the asset manager looked at retail in this case was because of the surrounding uses. And she did the correct thing. She went out to see if there was alternative uses for that site. There wasn't. The feedback was that they couldn't progress that, but that wasn't something I don't think that we were ever actually likely to do ourselves. What we may have done was seek planning for that and then potentially dispose the site there. In terms of us actually developing retail, we've never done it elsewhere. We have no plans to do that. The occasional mixed-use development where we have a coffee pod or like a fast food drive-through takeaway and things, we've looked at. But in terms of an actual retail development, it's not what our business is at all. So we have no interest in following up. Okay.
So in terms of where you are now, and you said your precondition still stands, that's still an up-to-date reflection of your position. That says that if you get to the point of that I'm paraphrasing it, but if you get to the point of that clarity that you're not going to secure planning permission for retail, you then move on to considering other options, and you've got the two industrial options that you've presented layouts for. You've also said, let me just double check where you say it, in the recognition at paragraph 3.2, you also say the landowner is willing to discuss a potential open market sale of the land, either to the council or any other interested party, once it's exhausted all other possibilities. So just for clarification, when you're saying there, that's what you do when you've exhausted all other possibilities, do you mean that between now and then you would be looking at your own planning application, your own development for a use that isn't retail? Is that where you are now?
Yeah, that's correct. I was looking at 4, 5, 6 use. Once we've exhausted that, and if we decide not to progress with that, then yes, as our position has been throughout, more than happy to either discuss private sale with the council or with any other third party, whether that introduction is through the council or whether that is directly to us. It's okay. Not in our interest. It's not in our interest to hold land that we're not going to do anything with. And as we've done elsewhere, we will sell land that we don't intend to build on.
Yeah. And are you able to say, at what stage you are in that thought process as to whether you are going to take industrial development forward yourselves?
No, not really. I think it'll be a decision I think we can make this year. We touched on it yesterday in terms of viability of projects this year compared to last year. So 2021 was really tough, obviously, because of COVID and because of material costs, etc. On the back of the Ukraine war, things like last year. That is all coming down now. So our recent tenders, and we've got a lot of sites under development across the UK just now, our recent tender costs are way down on where they were last year. So sites that weren't viable are becoming viable. So we'll be reviewing all of our sites again based on new tenders. And if we decide to take this forward, we will. We'll seek planning. If we decide, actually, you know what, it's not for us, then again, we will we'll happily speak to the council and happily sell the site.
And do you have broad or rough timescales around when you might get to the point of knowing whether you're going to take it forward yourselves or look to dispose of the land?
In terms of our budgeting, I would imagine that would be pre-October this year, because that's when our 24 development budgets will be set.
Okay. Yeah, that's all my questions then, given the update that you provided through Mr. Collar at the outset. Mr. Warren, do you have any questions?
Bear with me a moment. Let me just check. I don't want to ask the same question in a different way, so I'm just going to check what I've got here. So in 2.4 of your recognition, you've outlined kind of progress on sites across the UK and Scotland as well. Is it possible to just give us a feel for kind of how long it typically takes from kind of site purchase to seeing a project on site being completed, or otherwise a site being disposed of?
It's completely site specific. I mean, we don't buy land to develop, in a sense. But the land that we have now, we've acquired generally through portfolio purchases. So we're not a developer out there who goes and buys land with a view to developing it. We will develop our existing land, and if we don't, then we'll sell it. But I mean, you could be talking anything up to 2 years from standard. We want to build on this to actually starting building. So by the time we work through internal processes, we go through pre-planning depending on size, we go through actual planning, we go through tender works, etc. To actually completing a project, you're potentially up to 2 years. It depends if you phase the project as well. This isn't a huge project, but in terms of us, if we decided, yeah, you know what, this stacks up, let's bring this to market, and there wasn't a CPO hanging over it, and we just progress with it, it's not a huge scheme. And if we can get through planning relatively quickly, you could be on site start of next year. It's not this site isn't necessarily problematic in terms of planning. Shouldn't be an issue if we go for 4, 5, 6. Yeah, there's remedial works, etc., but it's not a huge site either.
And thank you. And in terms of those works that might be necessary before development could take place on the site, is there anything abnormal that you would not ordinarily expect on a brownfield site? Are there particular issues on this site that need to be overcome?
Not entirely. There's further demolition works that need to be carried out. Sometimes that can be an issue. Sometimes that can be a positive because it's actually been built on. A lot of the sites we're looking at just now have never been built on at all before. So in terms of structural foundations, etc., there's a lot more works to be carried out in those ones. That's not the case here. We do need to demolish slightly further the buildings that are there. There were previous services there again, which I think is actually positive. There's other sites round about which have services potentially to feed into. So again, I think that's positive. I don't think this is any more problematic than the majority of sites that we look at.
Okay. And whilst I recognise that your company acquired the site relatively recently, in terms of the vacancy of the site, why, in your view, do you think it's been vacant for so long?
I touched on this in my recognition. There was a lack of investment in Scotland in terms of people building industrial because there hadn't been a demand. Industrial stock really sort of took off in terms of like rents and stuff going up probably around about 2017, 2018. So prior to that, there really wasn't a market to build. And even when we bought it, so say 2018, it wasn't our intention to necessarily build. It wasn't what the platform was built for. We could buy industrial sites for an awful lot cheaper than what it was we could build for. So we could buy well-established sites that have been built in the 70s, 80s, etc. by councils for roughly £40 a square foot capital value we were buying for. To build at the time, we were talking £75, £80. So why would we build when we can buy at less than half the price? That has now switched because of the demand and a yield shift. It then became a little bit more profitable to actually start looking at building things, which is why people started to build. Now it's there or thereabouts, but it wasn't attractive at the time. There just wasn't a market for it.
Thank you. I don't have any further questions, so I shall look to my left to make sure there are no further questions. No, so thank you. So, Mr. Collo, over to you. Thank you. If you have any further questions for your witness.
I do just have a few matters on re-examination. Thank you, sir. Mr. Stewart, if you can go back to paragraph 3.5 of your precognition, where you made the comment that the threat to the CPO seems an unnecessary knee-jerk reaction to pre-application, and that rather than allowing any planning permission to follow the correct process, the Council have raised a CPO action to prevent a potential application being submitted. Mr. Devlin introduced you to the concept of the Certificate of Appropriate Alternative Development, which you indicated you're not familiar with. And I'm sure Mr. Devlin would agree with me to say it's to your benefit that you're not familiar with it, because actually they're awkward beasts. But just to give you a chance to properly comment on it, on the assumption that the Certificate of Appropriate Alternative Development is normally a mechanism to establish the financial value of the site because of possibility of alternative uses, and given that the Council indicated in the pre-app consultation that retail use was unlikely to be given planning permission, taking account of the two of those points, how likely would you have been to actually want to submit an application for a Certificate of Appropriate Alternative Development?
Yeah, highly unlikely. The feedback from the Council was very clear. They do not support retail development on that site. So once we had that, there wasn't really much point in pushing that.
Thank you. And you were then asked questions around the theme of public benefit arising from the circular, and you were asked about whether making the site oven ready would encourage someone to take on the site, and you indicated that potentially yes, and explained about cost and viability issues. And again, you discussed that further. But just to ask you, on this point about being oven ready, to what extent is demand a factor? In other words, the site being oven ready in principle is a good thing, but how relevant is the demand or not for that oven ready site?
Yeah, demand is definitely relevant. Like I said, oven ready sites, they may attract more developers, but they may not. I mean, if a developer's willing to undertake a full development, they'll generally be willing to undertake groundworks and site clearance works. For example, if your site clearance works cost 200,000, that doesn't just knock 200,000 off the price. There's a premium to be paid for that. So if a serious developer will generally be willing to take those costs on themselves if it means doing the little bit of work. So like I said, it may attract some, but not necessarily.
And then just to round off this point about demand, you were taken to the reference in your precognition, paragraph 3.3, about the unsold council site, and there was the discussion around the interest in the 24 Ridgeway site. 14 or 15 interested parties. You referred to the fact that Mr. Hare had said a couple of those were serious, but you didn't know how many. And I just wanted to put it to you that once the site is sold, that obviously satisfies the demand from that party because they bought it. To what extent do we know if there is still active demand from any of the other parties that were interested?
No, we don't. We don't know that, Tom.
Yeah. Thank you, Mr. Stewart. That was all I had. And Madam Sir, that closes the case for the landowner.
Okay, thank you very much. That's we've heard from all of the witnesses then. We would like to thank everybody for the participation today and also to yesterday's participants. We'll obviously go on to submit our report to the Scottish Ministers in due course, and we'll do that as soon as we can. I'm going to stick with the deadline of the 5th of May for the closing submissions. Does either party have any questions they want to ask or any other matters that they would like to raise?
Madam, the only formality that I wish to raise is, as previously intimated, the landowner will claim expenses against the council. So I'm really just making sure that before proceedings close today, that I've formally noted that, although I think it was part of the original objection in any case. So submissions on that will be included within the closing submission.
Okay, I'll note that. And yes, I think there was a reference in the early papers to that, but thank you for putting that on the record. Are there any other questions or matters to raise before we finish? Okay, then I will now close the inquiry. Thank you again.
Thank you.
Thank you.
Thanks, everyone.